Hello everyone and welcome to this Legal 500 webinar in partnership with Boyes Schiller Flexner, Challenges of a Modern Investigation. My name is Joe Boswell. I'm a senior member of the Legal 500's in-house legal research team, and I'll be introducing today's session. We're very lucky to have an excellent panel here with us today to discuss our topic, as they examine in detail some of the issues at the forefront of the investigations landscape. This session is interactive. If you have any questions at any point during the webinar, please type these in the Q&A function and we'll put these to the panel at the end of the discussion. We've also got polls for each of our topics, so please keep an eye out for these and cast your vote as soon as you can. I'd now like to throw over to our moderator, Tracy, who's going to introduce the panel and lead today's discussion. Tracy.
Thank you, Joe. Hello, everyone. It's great to be here. I'm Tracy Devaston. I'm a partner at Boyes Schiller Flexner. My practice is regulatory and internal global investigations. I've been at Boyes Schiller since January last year, and prior to that I was head of litigation investigations and enforcement for the UK and EMI at Barclays. So my experience has been in the financial services world, acting for financial services and corporate clients, both advising firms and individuals under investigation by the Financial Conduct Authority, the Prudential Regulation Authority, and many other global regulators and prosecutors. I've worked on all manner of investigations, whether issues arising out of the 2008 financial crisis, financial crime, tax-related, and of course, whistleblowing investigations. I'd like to now introduce my partner, Matt Getz. And Matt's practice focuses on investigations, white-collar defence and civil litigation. He's represented large multinational companies in some of the world's largest anti-corruption internal investigations. He's represented individuals and corporations under investigation by the SFO, DOJ, and prosecutors in countries as diverse as Switzerland, South Africa, Brazil, and Indonesia. And on the civil litigation side, he frequently advises corporations and individuals in matters involving fraud, bribery, and sanctions, and has successfully helped individuals challenge Interpol red notices and extradition. I'd then like to introduce Emma Emery. Emma is Group Litigation Director at Capita. She's a commercial litigation specialist who worked for many years in private practice and partner in a national law firm before moving to Capita 5 years ago. She's responsible for managing all material disputes and litigation across Capita, and her role involves working closely with the risk and compliance teams, in particular at the outset of investigations and hearings of whistleblowing complaints. Next, I'd like to introduce Marco De Gregorio. He's the Chief Ethics and Compliance Officer at Reckitt's. He leads Reckitt's corporate security and data privacy teams globally and is their data privacy officer. He lives in England, but has worked all over in the US, in the UAE, and Brazil. He's always worked in-house for a number of different organisations, so he'll have a lot of stories to share with us. He's worked at Ipiranga Oil Company, Royal Dutch Shell, British American Tobacco, and also at General Motors. And last, but certainly not least, I'd like to introduce Kim Morgan-Verlaque, who is the Chief Business Integrity Officer for Unilever. She's based here in London with a global team of more than 65 business integrity officers in each of Unilever's key markets. She's been at Unilever since May 2014, where she was General Counsel for Africa. And in 2017, she took on the added responsibility as Global General Counsel for the Home Care Division. She took up the role of Chief Business Integrity Officer in May 2019. And prior to joining Unilever, in fact, Kim worked at a number of the same places as me, including Barclays and General Electric, and also Morgan Stanley. So with this esteemed set of panelists, we're really pleased to be able to talk to you about the challenges of conducting a modern investigation. I'll hand over to Matt.
Thank you very much, Tracy, and thanks so much for having me all. The first topic that I'm going to discuss is one of the most vexed and actually emotional topics of an investigation, of how to manage it, the interplay between the corporation and individuals. We all work for companies, we work for corporations, we do the investigations for them, we seek to protect them. But at the same time, most of the people that we're interacting with are individuals. The people we interview are individuals. The people who may have or may not have done the issue which got the company into trouble are individuals. People whose data we look at are individuals. The people instructing us and directing us are individuals. And sometimes they're the same people as the people in the first set. So what do we do when these collide, when these interests collide? And I think that's an interesting topic and one that's quite tough. And then we're going to start off, before I speak with the panelists, with a couple poll questions about that, about how you feel about companies and individuals. So, Joe, could you put up the first poll question, please? Everybody will have a minute or so to answer it. Oh, we got both of them. So the first one, it reads for itself: who do you feel you are representing or ultimately responsible for? Corporations, senior executives, or employees as a whole? And if senior executives are implicated in an investigation, can you continue to advise them and the company at the same time? We'll give you a minute, a few more seconds to answer those. Joe, do we have the answers? Do we have numbers yet?
We have got a very clear winner for the first one. So who do you feel you are representing or ultimately responsible for? 77% of people have said the corporation, which is quite surprising to me, actually.
That's quite a lot. And the,
Yeah.
and the second?
The second, if senior executive implicated in an investigation, can you continue to advise them in the company? Only one person said yes, and the rest of the respondents were split very evenly between the other two.
That's very interesting. I mean,
Yeah.
I think, you know, that's what many people would think, but a quarter of people consider that your responsibility might be to senior executives and employees. So there's a clear difference of opinion there. Kim, what do you think? How do you answer these questions? Who do you answer to? Who are you responsible to in conducting investigations?
I think as a general counsel, you do have to wear both hats. So I mean, ultimately, you know, we work for the corporations that employ us. But as the Chief Business Integrity Officer at Unilever, people are my thing. That's what I'm here to do, is to ensure fair outcomes for our employees. So definitely, I think there is a space for you to play both roles. There will come a point where perhaps there is a conflict of interest. And when you are looking at legal liability of a company, or you're looking at holding an employee accountable for something, those are quite distinct things. And therefore, the way that you approach it, I think you can go down parallel lines for so long. And then if it really looks like there is going to be a need for the employee to, you know, be held accountable, and it's a legal liability issue, therefore then the paths then will diverge. And it's important then, as the poll says, really, that that individual will get external legal advice.
The issues become particularly acute for some companies, especially when issues become serious and they're in a deferred prosecution agreement scenario, because we've seen this in the last couple of years, that companies like Tesco and Sarklad and Serco, that they've had to, in order to get a DPA, give a statement of facts to the Serious Fraud Office, which is agreed, which names people, which names individuals who then have been investigated. And in each of those cases that I mentioned, the individuals have been acquitted. You could say no harm, no foul, but the fact that they've had to go through that creates particular difficulties for them. Although I suppose in each case, the company felt that, as you said, there was particular legal liability, and they had to make sure that they were telling the full truth to the authorities. Do you think it makes it? Do we think the companies did the right thing, or do they not have a choice?
I think it would be good for us to learn from those examples and recognize that those prosecutions have been unsuccessful, and therefore the need to protect the reputation of our employees should be a sort of sharper focus for us going forward. I think that would what I would like to see.
Yeah,
And I think that not all DPAs have ended up with individuals being prosecuted, although some would say that that's exactly where the SFO should be focusing, rather than trying to get liability for a corporate. But certainly a lot of pressure is put on companies if they want a DPA to offer up the individuals, and that's where I think this question comes up very highly. And as you say, Matt, even if you're acquitted, that often is after several years, and often not working, impacts personal life and all the rest of it. So it just shows how important it is at the beginning of an investigation that may not initially be one that the SFO is aware of, for ensuring that the appropriate representation is given to certain members of an investigation.
Absolutely. I think it's vital at an early stage to consider issues of representation, issues of data protection, if there are people that are concerned, issues where people might be particularly vulnerable. One needs to work with unions as well. All the employees of a company need to be properly protected. I wonder if there's any difference as to whether, based on the seniority of the individuals who might be implicated. That might be an unfair question, but Marco and Emma, I don't know if you have any thoughts on that?
I think for my organisation, no. I think there's been a real change in culture in my organisation to move away from that, actually, and ensure that all employees feel they've got a voice and are treated fairly. So I would say not in my organisation, but maybe a few years ago it would have been different.
Yeah, and I wonder also if there's a change over time in the provision of, for example, independent legal advice to people, to the extent companies pay for that for employees, or the extent to which it is provided to them, but at their own cost, and whether there might be directors and officers insurance. But you need to make sure also that people not only are protected, but are encouraged to help the company find out the truth of what happened.
Yeah, and to add to that, Matt, I mean, the insurance market for D&O insurance is really limited and getting smaller all the time, and even where parties do have that insurance, it may be very hard to actually to get a full recourse to it ultimately. So those are considerations that the company ought to be considering at the outset.
Yeah, there's also, sorry, Marco.
No, just agreeing, and I think the most important is that since the beginning, it's very clear and offering the employees involved the opportunity to have their own counsels and the insurance as well. I think it's just agreeing with what you're saying.
Yeah. There's also another individual aspect that maybe some of you have some experience to share with. What happens when you, as a senior compliant person in compliance or the law functional risk, what if you're asked to help with an investigation? What if you're asked to get involved in an investigation, say for your firm or for a previous firm? What are your responsibilities there? Yeah, maybe you have something to add on that? Yeah,
well, my responsibilities, I think it's split first and foremost to the corporation, but you have to ensure that an employee isn't treated unfairly until there's been a proper investigation and conclusions have been drawn. It's quite a fine balancing act sometimes to get it right. But yeah, I mean, firstly to the corporation, but always be mindful that until conclusions have been drawn, they are employees, they're an extension of you and they're performing services on your behalf.
Yeah. And I wonder sometimes, you know, if any of us have ever been part of an investigation, you know, we can also see that, you know, we need to be mindful of our own responsibilities, both to the corporation and, you know, to the truth and to our colleagues. One thing I'd like to bring up, you know, it's something that we may or may not discuss. When senior individuals get involved, when you find out they're implicated, that can be one of the most difficult things for a company, especially once an investigation has moved on beyond a certain stage. I've been involved in some investigations where that has happened, and it's never been an easy thing for the company to deal with or for the lawyers. The best thing that we've been able to do is hopefully that the people above the chain of the senior executive who is implicated take their own responsibility seriously, you know, and one needs to get their support, you know, is to need to get the board support or the CEO's support to understand that there are certain senior individuals who can no longer be involved, who you need to look at. And again, this is a sensitive issue which has to be dealt with in a different fashion in every time. And I know how we have, and I was just wondering if there's any more insights that the panelists can provide on that.
I'll add something to that, Matt. There's so much importance in terms of the governance that you have around how the investigation is conducted, to ensure that anyone who is the subject of an investigation or even has a bit part in the investigation, that they can't be seen to be controlling or even having access to information as to the progress of the investigation. And you know, it's different, it's done differently in every company, but setting up a subcommittee or a special committee to manage the investigation and to ensure, but also to ensure that that senior executive does understand that things are being done and does understand that these things take time, and depending on what type of investigation it is and whether external regulators or prosecutors are involved, that can be quite lengthy. And Emma, I think you wanted to say something.
Yeah, I was just going to say also that if you have processes and procedures, which most organisations do for dealing with these, is making sure you implement them and stick to them. And just because it's a very senior level investigation, don't be sidetracked or even railroaded. And as an advisor to the company on that, I think you have to be very firm in making it clear that it's no different in this situation, and make sure that your processes are implemented properly. Certainly if there's an audit of it afterwards, it's really important that you don't get sidetracked from that because it's a more significant senior level investigation.
Incredibly important point. It's the exceptions from the norm. It's the exceptions from the well worked out policies which make regulators think, well, this is just paper, you know, that the company has a nice policy but doesn't run properly in practice. And ensuring that you keep to the proper policies is key. I'll just add a last point, maybe moving lanes a little and not talking about book too much, but this is also one of the reasons why sometimes it's important to get external counsel involved, including external counsel who haven't been regular counsel for the companies before, you know, so that they can add some of that independence and not, you know, and be able to show that things are being done by the book and not, you know, protecting the people who were there before. I think, unless there's anything else to add, I think we can go on to our second topic, which Tracy will take up from me.
Thank you, Matt. So our second topic is relating to remote investigations. And I think all areas of business have been impacted by the pandemic. And one of these, of course, is the conduct of investigations. With traditional investigation techniques, we've always assumed the ability to travel, to meet face-to-face and review hard copy documents. And of course, since February, March last year, this has been turned on its head. And so of all the investigative techniques that have had to be adapted, one of the most challenging to successfully recreate is the interview. And interviews are critical for gathering facts and information that would otherwise not be available or identified, or in order to confirm conclusions that you want to see whether they can be reached from documents. And so I suppose prior to February last year, for many, interviews by Zoom or Teams were few and far between, and it certainly wasn't a process that was welcomed by regulators or prosecutors, and that's either locally or internationally. I guess, and it'll be interesting to hear from all the panelists, but whether or not you were already conducting interviews prior to the pandemic by Zoom or equivalents, or whether it was after several weeks of lockdown and with no end in sight that it became obvious that couldn't leave the investigations and interviews would have to take to take place. I'd just like to ask a poll question to the audience, which is, what do you prefer, in-person or remote interviews? And then there is a second question, which is, will you keep doing remote investigations post-COVID? And whilst you're all putting in those answers, I'd like to go to Kim, and Kim, for you to maybe tell us your experience as to whether or not you were conducting interviews remotely before, and any lessons learned from conducting remote interviews.
Yeah, Unilever certainly only started doing remote interviews as a reaction to the pandemic. Our preference has always been to have a face-to-face interview. We had to change that, and some of the best practice tips that I can sort of share with the audience that we found has helped us get to the bottom of things more easily. So we have a culture really, actually, when we use Teams in the business on a general basis now, to have our camera on. So that has also now sort of flown through to our interviews. So that is mandated. In fact, I've never had or heard of anybody refusing to have their camera on. So that gives us some degree of some sort of personal touch. You should build in more time, though, for the interview, knowing that taking the time to build a rapport, it does take longer, and making sure that the person that you are interviewing is at ease. So resilience and well-being, sort of mental health is very much sort of top of mind. When you're talking to somebody on a screen, you aren't able to read their body language quite so much. So check in, start the interview by finding out, how they are, so have that personal touch. And if you're worried about, their mental state, then pause, make sure you have more regular breaks during the interview, so that, people do feel that they are being able to respond with their best response. We're not trying to catch people out when we interview, we're trying to get to the bottom of the fact base. We ask that people confirm that they are not recording the interview. We ask them to confirm that they are by themselves. Of course, that is built on trust. There's no way of us knowing one way or the other if that is the case. We also try and make sure that the full disclosure of what we want to talk to them about is made up front. Now, in some types of investigations, that's not possible because you're worried about people getting their stories straight. But otherwise, in the vast majority of them, give people the opportunity to hear what it is you want to talk to them about, so that they're not in a state of shock. And therefore, you don't really get much out of the interview when people are like that. We've also introduced a top tip around making sure if you print stuff out at home, it's confidential. Don't just put it in your waste bin in the kitchen, but dispose of it confidentially. Think about where you're having your interview. Is Alexa listening in? Are the neighbors listening in? So there's a piece around confidentiality and just sort of maintaining that. We've found on investigations where we can't get to a place, we've actually used very much more local firms to help us, which is something we would never have done before, with quite good results, in fact, actually. So not people with the same sort of profile that we would ordinarily have used. And that's been quite successful. And we've also been able to say, well, if you want to see what a place looks like, actually you can use mobile phones. You can sort of strap them to your head or to your chest, and people can walk around the site or the factory to actually, if you want to sort of see where something might have happened. We also have started to use that very basic technology. Everybody has a mobile phone, and most places have got signal. So that's also allowed us to get to places that we can't physically be at.
Great, thanks, Kim. Emma or Marco, anything you want to add to that?
Yeah, let me jump here just to say, look, I fully agree with Kim. I think having the proper planning for the investigation is a very good starting point. Prepare a strong plan, interviews in advance, share the details with the witnesses and investigated employees. In Reckitt, we felt in the beginning, I think the most relevant impact was that we have a standard operating procedure defining 60 days, the ideal timeline for the investigation to be concluded. And unfortunately, during the pandemic, all the other priorities and personal circumstances, homeschooling, we couldn't. finish the investigations in the timeline that we were envisioning to. But after, I would say in September last year, when we started to realize that unfortunately COVID was here to stay, I think people adapted in the new normal, and I think we started to get back on track in terms of our timelines. I agree with Kim, and I would just add one final thing, that we have to be very mindful about individual circumstances. So we have people sharing the same space, the same office, having meetings from their kitchen table. And before starting asking very sensitive questions about their integrity or other matters, that we have to ask them if they are alone, if they are in a protected environment, if they can keep confidential the conversation, even knowing that confidentiality, mainly if they have camera off, we cannot guarantee anymore, because they can be recording with their phones and other devices. Just to add those additional comments.
I think you make a really good point there, Marco. I mean, one of our best practices is that we, in advance of any interviews taking place, we send in advance what our expectations are. So that we expect that the camera will be on, that we expect that they'll be in a room alone. And then a question has come in asking, how do we know whether someone is sitting behind someone answering questions? Well, also we write that in advance, that the expectation is that you're sitting alone. Depending on the type of interview, there may be a situation where you actually ask the person you're interviewing to show you that there's no one else in the room. But that would really depend on the topic, and there would already, one would expect, be some level of distrust for you to be asking that question, and that might go against exactly what Kim was setting out about creating that rapport. I see another question has come up on the chat about whether we think body language is altered by remote interview. Well, the real issue with body language is, in fact, you often can't see the body at all. You might be sitting as I am, where you can only see my head and part of my shoulders. One tip is, of course, to ask people to move the screen back or to sit back so that you can see more of them. And body language is, of course, hugely important when it comes to both how people are reacting to certain questions, but also in developing rapport as you interview.
Can I say something controversial about that? You know, especially in my experience, not only of interviewing a lot of people over the years, but also speaking with other people who are interviewing people and learning from senior lawyers as well. It's often difficult in person, and it's difficult to tell if someone is telling the truth or not. We think we're better at it than we are, in fact. And we think we can tell from the way they hold their hands or the way they sit. And often we get things wrong. And maybe I would think that, you know, remote interviews will require us to be more disciplined and be a little more humble and work more, you know, thinking that we can't exactly tell what somebody is doing, and use proper investigative techniques and base what we're asking them on what we know and what the documents, without being too overconfident. It's just a thought. I don't know if anybody has a follow-up from that.
I mean, look, there are a number of.
Oh, sorry.
Go ahead, Emma.
I do think we do need. I feel we need to be more prepared for interviews over video. Certainly, my experience is actually I quite often deal with them in quite contentious and very sensitive situations, and people don't want to be on camera. And I've no idea whether they've got a lawyer present, whether they have reams of advice sheets and prompt notes and everything in front of them. You just don't know, and you have to be very careful how you tread. Whereas if you're in the room with somebody, you can see what resource they have access to, and you can play it in accordance with what you can see and feel there. But when you can't, you do need to be much more cautious as well. I think I've had a lot more interviews cut short and reconvened as a result of that kind of environment. Although that's the benefit of doing things virtually, is that they can be rearranged much more quickly than they can in person. So I think, to Kim's point, they do take longer and you do need to be more prepared, but it's much more convenient to reconvene.
And that's completely right. And there's less chance of interviewers complaining because or saying they can't attend an interview because they have something important happening on certain times, and so the travel doesn't work. It really removes that possibility, even if they do delay once or twice. I mean, I think the no need to travel has advantages for everyone who don't necessarily want to travel all over the world when they're conducting an investigation. And another, it could be an advantage or a disadvantage depending on which side of the table you're sitting on, but it allows more attendees without the number of people being overwhelming for the person being interviewed. And you can organize that, for example, by asking some people to turn off their cameras, they're the ones who are just listening. At the same time, there are a number of disadvantages. If we go back to the section that Matt was talking about earlier about whether you'd have representation for your senior executives or employees in an investigation, it's much harder for them not to have their representatives in the same room with them, or to be able to speak to them whenever they want. And of course you can have breaks at any time, but it also means that it also might cause some disruption to the course of the interview.
There was also a question that came in about recordings, quite an interesting one, with if regulators' expectations change in terms of provisions of recordings. Now, you don't have to record a remote interview, but you can record a remote interview. By the same token, you don't have to. You can also record an interview in person. But it seems that if you do record it, you are always creating another piece of evidence for the regulators to get if they want. Any views as to whether you record interviews virtually or how people react to that? I know this webinar is being recorded and we all seem pretty comfortable so far, but hopefully this is less contentious.
I mean, if we are intending to record an interview, it's really important that you advise both the interviewee and all participants first and obtain their consent, unless, of course, this is part of the criminal investigation, in which case their consent may not be required because it will be a different kind of interview altogether. So Marco, Kim, Emma, do you record interviews? And if so, in what situations? And if not, why not?
I don't, and I would advise against it unless you had to. And that's mainly from a legal privilege point of view.
Yeah, it's same for us. Our default position is not to record. If you do want to record, we have a policy and procedure on it that you're required to follow. But it really is in the default minority that would be the case.
Bracket as well, we don't record as a general rule, but I think during the pandemic, I've seen more and more events where we need to bring mainly external lawyers present, that we are recording one or two. I think became more common to record last year, always with external advisor, of course, in a very high level case, and following also our policies and procedures when this happens in terms of privacy, notices, and etc.
Joe, I'm assuming the answers have come in to our poll questions.
Yes, they have. Hopefully you can see those on screen now, but 90% of, well, 91% to be exact, of respondents would prefer to do in-person interviews.
So I think that's not surprising at all, but the second answer about will you keep doing remote investigations post-COVID is more surprising in that 64% say yes and 36% say no altogether, so as if there will never be that possibility. And I think the reason I find that slightly surprising is that even the regulators and prosecutors who were slow to come to the table when it came to remote interviews are now holding these. So whether or not they'll only go back to in-person interviews is something to be seen. I think it would now be a good idea to move on to the next topic. And I know that it's one that there's a lot of interest in, because I can already see a number of questions coming up relating to it on the chat. So Matt, over to you to talk about whistleblowing.
Whistleblowing. Thank you very much, Tracy. Well, we've got a question for this. Joe, if you want to put the question up and let people answer it while I start mentioning a couple of interesting things. There's your question, an increase or decrease over the lockdown period. While you answer it, I will tell you what some regulators have found. According to the FCA, whistleblowing to the FCA is down over lockdown, about between 10 and 30%, depending on how you count it. According to the Securities and Exchange Commission, whistleblowing is up over that period, also about 10% or so. Obviously, you can't have the same cause for both effects, and it's not clear why exactly these have happened. With the FCA, it may be that fewer people see what's happening, they learn less about whistleblowing or about issues that require whistleblowing. But from the SEC point of view, they speculate that maybe with people being away from the office, they have less concerns about telling an authority what their own people are doing, or they're happier to go to an outside authority than internally to the company. We'll see your answers in a minute. But as Tracy said, we've got a couple of great questions from people about whistleblowing. Quite appropriately, most of them are from anonymous users. So here are some anonymous whistleblowing questions. And the first one is, I think, the broadest question, and maybe, Marco, you could share some of your experiences. One person asked, how do you make it easier for a potential employee to blow the whistle? And I think this was very interesting, without feeling guilty or concerned about their job security. And those aren't the same thing. So I wonder if you could talk at all about your experience there in helping people become comfortable about doing so.
Yeah, and indeed, a very difficult decision is a great question. I think everything starts from creating the right environment and the right culture in the company. I think the employees must trust on the organization and trust in the leadership of the organization. The company leaders, I think, must build the view that the company has a strong set of values, a strong compliance culture of integrity. And only when the employees realize that, not only by their words, the presentations, but on their behaviors as well, I think they will trust and bring the case forward. I used to say that everybody's compliance in a compliance meeting, in a town hall, I think is when you're approving budgets, you're approving targets, you're approving claims for our products, tough decisions when you see if the company is doing the right thing or not. And create a culture where employees can present their cases and are not retaliated for there is the starting point. Only then they will really trust.
Yeah. There's the other part of that question as well. Without feeling guilty, the person said, what do you see? Why do people feel guilty when they are engaged in whistleblowing? Are there areas where they feel bad about the effect on their colleagues, for example? And is that something to be dealt with?
Yeah, for sure. And I think it's a tough decision but you have to think about not on the negative aspects because they probably bringing facts about a colleague or about a situation involving the company, but you have to think that it's helping to create the right environment, the right culture. Think on the positives and not on the negatives, I think is what the company needs. And if the case is not bring for us to solve, it's better that we know than this is brought to a court or to a regulator. It's better that we know, right? Is my suggestion.
Yeah, absolutely. Do you feel, and this is a question also maybe for Kim and Emma as well, that there are differences in different areas? Do people feel, can you get people more comfortable with whistleblowing, say, relating to theft or corruption or safety or harassment? Are there differences in the way the programs work and the way people's minds work in the company?
I think what we found at the beginning of the pandemic was that people were more reluctant to raise concerns because they didn't want to contribute to what was already an awful situation for people. So it wasn't really in particular code policy that they were concerned about, but certainly I think that there was a desire not to make people's lives worse and not be responsible for them potentially losing their job. We've sort of seen things sort of measure out a bit in the past period of time. So whilst there was an initial drop in cases, then things, you know, sort of stabilized. And actually, in the last 6 months or so, we've seen an increase in cases. And interestingly, actually, as some of the offices have returned, and our factories have remained open the whole time, but actually in terms of the markets where the offices have gone back, we've seen again an additional increase of our cases. And also what we've seen over the course of the past sort of 15 months is that our substantiation rate has got better. So people are taking the time when they are raising a concern to give more details. And that might be because they're at home and they know that there's nobody looking over their shoulder at what they might be writing. And therefore they're able to take the time to think about what they want to say and complain about. And that obviously helps us be able to substantiate a complaint if we've got more information. Yeah,
because you don't just want more whistleblowing, and obviously, in fact, in a sense, you don't want everybody to be blowing the whistle, because then there's something seriously wrong at the company. But you don't just want people more; you want better quality as well. You know, you want people to put out things that are about serious matters that you can deal with. So some of the questions, in fact, that have come up, quite a few of them. Person asked, how do you what questions should you ask a whistleblower to establish credibility, or how do you identify genuine whistleblower information from false information quickly and efficiently? The audience member asked, which is a great question, and I wonder, Emma or Marco, if you have any tips on that. You know, how do you weed up the good from the wheat from the chaff?
Yeah, I think
there's an element of having to go through the process inevitably. But I think it comes with experience, I guess, the types of questions that you will ask to try and understand really whether it's genuine or not. But we have a process and a culture that, you know, everything will be looked at. We don't overlook anything. But there's maybe a level of depth of investigation that you may go to depending on what your initial requests and findings are.
Yeah. Marco, you were going to say something?
Just to add, and I think you have to try to identify why this is being brought to our attention, right? What's the interest, what's the intention of the whistleblower representing? And sometimes we ask him, look, what would be the ideal resolution for this case in your view? And we ask this question, we try to establish a very direct connection with the whistleblower in order to get this information. What makes things more difficult is when the case is an anonymous case, and this is an important topic as well, and it's linked to what I mentioned at the beginning. If you create the right culture, the number of anonymous whistleblowers will be reduced. And if you have a case that is identified, you have more chances that is substantiated, because you can obtain evidence is much easier and interview the person. Mm-hmm. An anonymous case is more difficult.
Can I ask, because clearly most countries, the United States requires it, but most countries don't require that you accept anonymous whistleblowing. Clearly you will accept it in your firm. Kim and Emma, will you listen to anonymous whistleblowing? Is that a possibility?
Absolutely. Yeah, I mean, it makes it more difficult if we only get the allegations and we have no way of contacting the reporter, or they don't reply. But absolutely, I mean, we have the majority of our complaints do come through our business integrity officers, which is great. It shows they trust the process. But there is certainly a percentage of anonymous complaints, and I wouldn't want to sort of stop people from feeling that they can do that. We know that one of the biggest barriers to speaking up is a fear of retaliation, and therefore that mechanism of being able to do your report anonymously, it's critical for us to be able to allow people to report without that fear of retaliation.
Yeah. And on the question as to what you should ask a whistleblower to establish credibility, the whistleblower may still be credible even if they're a disgruntled employee or former employee. They may have things that they're disgruntled about, but the issue that they're raising may still be true. And so it's very easy in an investigation to for someone to be written off because, you know, they've done something wrong in their past, and so maybe someone thinks they're not to be trusted, but they may still be raising a really critical issue. The complication really arises when the issues that are raised are spurious or worse, malicious, and policies can be drafted so that a different approach can be taken once it's proven that the issues being raised are malicious. Again, that will depend country by country because some laws may be different on this.
That indeed was another question. You know, one person said that asked the new EU whistleblowing directive seems to have no responsibility on the whistleblower. How can we then protect companies from abuse of the whistleblowing system? Do you feel that's a concern? Do you think the system might be abused? Or do you have to accept the fact that there are going to be some bad complaints and you have to rather get the skills to differentiate those from good complaints?
Yeah, I think we have to make clear that we accept the anonymous whistleblowing reports. We investigate all the cases, but they should be presented responsibly as well. So if during the investigations it was identified that was not truthful what was presented, or there was any abuse by the whistleblower, this can constitute a violation of the code of conduct in itself, right? And you have to be very careful. It's more difficult if it's anonymous, but we do have mainly employee relation cases, grievances cases, a lot of targeted cases, but we have to be careful. We have to show examples in where it didn't work well before and show how the company takes this very seriously.
I've worked on a matter where a whistleblower has, someone who claimed to be a whistleblower raised many allegations, very, very discreditable allegations against our clients. And the whole purpose of it was that they'd put something in writing that they would then leak to a national newspaper, in fact, to several newspapers, so that it would be published and then questions would be asked about our clients. Turned out to be malicious, but the whole purpose of it was to enable as much bad press and harming the reputation of our clients, and trying to use the whistleblowing process in order to do so. So there definitely needs to be controls over the information that's being received and how it's used, and to the extent that the whistleblower isn't anonymous, to ensure that explanation is given to them that, you know, you will investigate, but you expect this to be kept confidential while the investigation is ongoing.
And final word, the EU, the whistleblowing directive says that any complaints must be responded to in 7 days and dealt with within 3 months. Panel, is that realistic? Marco, Emma, Kim, any views?
Yeah, I was waiting. Look, can be, right? What we do, as I mentioned, we have 60 days as our internal target, internal deadline, but I would be lying if I say in 100% of cases we manage to get these 60 days timeline. So what we do is we have a formal process. Whenever we assign a case after a triage to an investigator and he or she requires more than 60 days, we'll just request an extension with some justification, and then we have some recording on the reasons why, and with that I think we have some solid reasons for why we are not taking the 60 days with our policy, right? But indeed it's been more difficult, as I mentioned, mainly during the pandemic.
Yeah, I'm sure. Well, I think it's time to move on to the next topic, but before we do, Joe, what are the poll answers for the whistleblowing question?
Well, a little over half said that things have stayed roughly the same. I'll put them up on the screen so you can all see that. But only very few people said that it's decreased, and around a third said that it's increased. So I'd say probably there is an increase overall.
It seems like it. Maybe that's true, that once you're away from people, you find it easier to actually talk about what's going wrong. Tracy, back to you.
So in the current enforcement environments, corporates should be prepared for increased scrutiny and be ready to navigate multiple legal and regulatory regimes. You may be conducting an internal investigation and have to address the question as to whether you need to notify the regulator, and if so, when to do so. And thirdly, if more than one regulator, are there any advantages or disadvantages in informing one before the other? So our poll question here is, if you could just put that up, please, Joe, is if you were to have a regulatory issue that you think should be notified the authorities, which regulator do you speak to first? Or is it US, let's say it was the US, the UK, or do you notify both at the same time? We'll come to the answer on that later on. Well, I mean, I'll start off with a typical legal answer. Well, that it depends. But of course, there are some instances when you may have an obligation to notify within a specific time limit. For example, 72 hours for DPA breaches. Certain regulators have rules that require notification immediately or promptly, and others, whilst it isn't written in their rule book that they expect to be notified first, they expect to be notified first. And so how you manage that in practice is something that often involves some real working of sequencing, having different people available at exactly the same time to speak to different regulators, and of course, thinking at that time of exactly what you're informing them, because it's about parity of information as well. Matt.
I'll say something about that as well. There are so many possible regulations that have some kind of a US issue. I mean, I know it sounds like a joke to say that the US regulators, the prosecutors think that they have jurisdiction whenever US dollars are used, but frankly, that still sometimes is the case. So I think if you think there is a possibility that there is a US connection at some stage, if it's going to go public, the regulators will think that as well. And I've had, in my experience with certain multinational ones, you don't really want the US taking over everything, but you don't want to keep away from them, because then that could be much worse for you. What one can do sometimes is try and work with a regulator that has, more natural jurisdiction, be it in the UK, be it in France, Switzerland, or elsewhere, and work with them, go to them and say, you're going to the US quickly, but we think, this is something that you will take major responsibility for, and actually try and get the regulator that not is better or easier, but actually makes more sense, to try to talk to the US and say, this is the way we should split things up.
Yeah, absolutely. It's often works in your favor if you can get the regulators to discuss amongst themselves who should take the lead. But of course, trying to make it clear who you would like to take the lead. The danger of one regulator finding out much later than another is, first of all, you might have breached certain cooperation obligations or notification obligations. But secondly, you might end up doing the investigation twice. Because, and I've seen this in practice, that the regulators seem to be interested in slightly different things. And so they will receive an investigation report that one regulator was completely comfortable with, but decide to take it down a slightly different route. And, from a GC position, of course, you're not just trying to protect and defend the company, you're also looking at the cost of this. And we all know that these costs can be significant. So I think when dealing with regulators, it's really important to get strategic counsel involved to assist with those kind of issues that you wouldn't normally be dealing with when your investigation is simply internal.
I will give a caveat that most of these kinds of savings these are real savings that can be achieved if you do it right in terms of your time and your internal cost, your internal spending. It doesn't necessarily mean that the fine the US wants in the end is going to be much smaller, because there have been a number of cases where the US has sat around and let the other authorities take most of the work, and then right at the end said, okay, well, we accept what's been done, and this is how much you will need to pay to settle the case here, and it's still a very, very large number. But
Joe, would you show me the results on that poll question?
Sure, there we go. So the clear winner is that they would try to speak to both at the same time, which I suppose isn't too much of a surprise, but in practice that might not always be possible.
Yeah, and interesting that so many thought you might speak to one rather than the other first. Shall we move to our final topic? And I'm just conscious of the time, so perhaps for our final topic, we just want to talk about where we see the most investigative work coming from in the medium term. If we put up that poll question. Give everyone a chance to and while they're doing that, how about if everyone, each of the panelists speaks for a minute on what they think is going to be the main topic of for investigations. Emma.
I'm happy to go, yeah. I think what I've seen most of in the last year has been around fraud. Definitely. I'm just looking at some of the other options, conduct and culture. Historically, there've been quite a lot for us. It depends on the organisation, I think, that, and what the culture is within your organisation. But I think certainly, and possibly as a result of the pandemic and people's job security and things like that, we're seeing a lot more fraud investigations as a result of that. Yeah.
Thank you. Marco?
Okay, as Emma mentioned, it depends on the company, right? So it depends also on the moment of the company as well. In Reckitt, we just issued a new set of corporate leadership behaviors, and there's a large number of cases coming from several employees calling out behaviors that some leaders are not following. It's a new tool. So in Reckitt, I think it will be always focused on conduct and culture. Those will be the highest volume cases. Cases linked to mental health, how the company is pressuring to get results and structure. I think those are the majority of the cases. But I don't think those will be, if you ask me what will be the higher risk type of cases, for sure, I dedicate much more time and attention to a bribery or corruption case or to a data privacy case than I dedicate to those others that are also very relevant. But the bribery cases, the risk and the complexity are much higher. So in terms of volume, conduct and culture.
Okay.
I expected us all to be different, but actually I wasn't going to go with conduct and culture. And I think from a respect, dignity and fair treatment, so respecting people is our code policy, whether there are going to be more complaints from employees saying that other employees are treating them unfairly because they are not performing it the way they should be because they've got long COVID, or in fact that they're just not as resilient because of what's happened through the pandemic. And whether that then becomes a sort of cause of action where people are very rude about their colleagues that they see are not as strong as they expect them to be, and whether we would get more of those sort of conduct and culture allegations in respect to that. But I think externally, I would certainly go with privacy breaches and cyber crimes. If we're looking at what a regulator would be interested in, I think it's quite different to what I would look at from an internal perspective. And I think that's certainly, we've seen the uptake in that, and I expect that to continue over the next 12 months.
And Matt?
Well, I'm not going to be as different either. I could talk about sanctions, but take it from what Marco and Kim was saying, the low volume, high magnitude events over the next few years and the unexpected ones, a lot of that's going to be data and cyber. And I think, you know, we can look at a couple trends that are going on. It's a bit like what's happened with sanctions and money laundering over the last 10, 15 years. You know, there were more and more investigations into proper sanctions and money laundering breaches. And here we have the analogy of actual data breaches, and there are going to be more data breaches because there is more data. It's more valuable, and there are more bad actors out there, more hackers, and more ways for people to just lose data. But at the same time, in the sanctions and AML world, there were a lot of investigations and a lot of fines and a lot of regulatory actions for bad practices to do with that, even where there weren't actual breaches. And people have had to get their act together regarding sanctions and money laundering. I think they're still some years behind the curve in getting their act together, really, in terms of protecting all the data of their employees, their customers, and others. I think there's going to be a lot of resources that are going to have to be devoted to that over the next few years.
And then finally, I agree with all of you. I mean, I suspect we're going to see an increase in all of these areas, but I'll say conduct and culture as well. And within that, whistleblowing, the FCA have set up from a regulatory perspective, they have now set up procedures whereby every whistleblower will have someone assigned to them to meet with them to take down, so that they can show that that whistleblowing is taken seriously and to get updates on an investigation. In fact, I'm not sure how much information they'll be able to provide, but that's what they're putting in place. I think that it also other conduct and culture issues, things like non-financial misconduct. So, you know, for regulated firms, the CEO of the FCA recently made it clear that conduct relating to diversity is a regulatory issue. And it's, I think that non-financial misconduct like sexual harassment, discrimination, diversity, etc., is already a huge topic for internal investigations, and it will be interesting to see if this also becomes an enforcement issue in the future. So I think that brings us to the end of the topics that we were going to discuss.
Do we have time to answer a couple of the questions? Joe?
Yeah, absolutely, yeah. We can take a few questions.
I don't know if anybody wants to put a new question. I noticed a couple that there was an interesting question about cross-border investigations. It's Mike Nichols said there were issues with cross-border investigations involving Switzerland, and are there further constraints and issues for cross-border investigations with the EU following Brexit? And I got to say that they've never exactly been easy. There've always been, those of you who've had cross-border investigations involving France, for example, has been particularly difficult. The fact that we were in the EU with them didn't make things any easier. It's not going to get easier now, but that might be something that is worse for law enforcement than for us. Our issue, talking about data and cyber, is whether in the next couple of years the UK will still have an equivalency ruling and that we can share data across the EU. There might be real difficulties doing any cross-border investigations with people in the EU if the UK is totally kicked out of the EU data system.
I'll answer one of the questions, which is, would you agree to carry on the interview if the interviewer doesn't agree to put their camera on? I think it depends why. If they're not putting the camera on because there are difficulties with the connection or something along those lines, but otherwise you have to ask the question as to why they're refusing to put the camera on. And, you know, is there someone else in the room? Do they have documents in front of them? So you would need to weigh up the urgency of getting a response and understand exactly why this question is being raised in the first place.
And I saw one about an employee who puts false documents on the cloud and if a suspect hides fraudulent documents in the cloud and hands normal documents to investigators. How can you locate the cloud and get back those files? Well, first thing I'll say is it's not easy, especially if somebody does it totally on their own account. But people often make mistakes. People often leave gaps where you can find out. We recently helped a company where employees had stolen documents and put them on a very well-known cloud provider. And we spoke to that cloud provider, you know, and we spoke to them and we figured out what the employees had done. And we managed to, you know, encourage the employees to ultimately do the right thing, because they would have been in a lot of trouble otherwise if they didn't give us access. But this does show that there are more and more ways for people to hide things. And it shows also why sometimes, especially those in sensitive areas, you need to be very careful of the access people have from work to the cloud, to outside providers and the like. But it goes into another question about social media. As I say, people make mistakes, and, you know, proper investigation can find out exactly what they have done more often than you think.
I was just going to say, I'm not sure if we went over the results of the last poll.
Well, let's put that up.
Yeah. So conduct and culture is in the lead, but there's a pretty even split between that and data, cyber, and fraud. Bribery and corruption a little bit below, but sanctions, theft and accounting fraud, and procurement lagging behind. No one thought that theft and accounting fraud is going to be the interesting enough.
I hope so.
I think it's coming back.
Thank you. Well, I would just want to say thank you to everyone for joining us today, and thank you to Marco, Kim, and Emma from Math&I. We really appreciate all your insights, and let's see how many of these investigations are going to be coming our way for all of us over the next couple of years. Thank you.
Thanks so much, everyone. Yeah, just to reiterate, it's Legal 500 webinar sponsored by Boyes Schiller Flexner. Thanks very much to our wonderful panelists and audience for spending your time.
Thanks,
a lot,
Joe.
guys. See you soon. Bye.